7. Law and civilization. When one turns his eyes from law outward, the first effect is to make law shrink into seeming insignificance. There is so much outside, and it so obviously bears in upon and changes and remodels law itself. After a further, while so to speak, as the eyes grow adjusted to the glare, one attains a truer picture. One perceives an interplay of causation between law and the world outside. One begins to suspect something of the nature of the interplay. It may have value for you. It may shorten the period of refocusing. It may indeed stir you to break the surface tension of the law and take a slow look around. If I sketch here some outline of what I think one comes to see when he sets out to survey law's relation to civilization. By civilization, I mean what anthropologists call culture, the whole setup of society, including the ways in which we act and the ways in which we are organized, including our material and intellectual equipment and our ways of using both. As to law, you know roughly what I mean. But it is not workable to tie to a single meaning when dealing with primitive times and with our own as well. You would not have me deny the presence of law in a society merely because there were no state officials. There was an international law before League of Nations or UN. Both law and state have grown, and grown gradually, and at times quite independently of each other. If we are to watch law's relation to civilization, we must therefore watch law's development in civilization, and what we watch will be a different thing from time to time and place to place. The sole inescapable common element is dealing with disputes. The sole inescapable common focus is the relation between the ways of dealing with disputes and the other ways of living. Hence, when I am talking of a ruder culture, before the state and the state's courts, I shall be thinking in the first instance of established ways for settling disputes without resort to violence by the contending parties, or even for settling them by violence, but by violence bridled and curb-bitted. As the state of culture concerned grows more advanced, I shall be introducing other ideas commonly associated with this symbol law, e.g. the regular tribunal. As soon as a state appears upon the scene, the idea of action about disputes by the officials of the state will of course appear, and will be contrasted, say with the settlement of a strike by the mediation of a prominent citizen. And that other aspect of law, regulation by officials for greater convenience and safety and prevention of disputes, will play a part. And there will come in from the beginning the notion of some considerable regularity in anything that is done, some recurrence and predictability, and some conception that there ought to be recurrence and predictability. The ideas of precedent and rules for these are aspects of any institution, legal or other. If, then, I am treating law as a part of government, and especially as the dispute-adjusting machinery of government, and civilization as the whole of the ways in which we live together, and of the things that we do while we are living together, it would seem to be clear that law becomes for me a part of civilization, and the question of law's relation to civilization becomes a question like that of the relation of the nervous system to the human body. It is not a matter of something from outside being turned over to or compared with civilization. It is a question of what role law plays in the same civilization of which law is itself one of the vital parts. I think we make the best approach to that if we distinguish first law from order. Without order, there is no group life, there is no group. If the members of a group do not in some manner manage to live together, if their respective conduct is not to some degree oriented with reference to each other, if there is not some cooperation, some self-restraint, some specialization, and some predictability for each one as to how the others will act when they cross his path, you have no group. And a group becomes more a group and less an accidental accumulation of several individuals in one spot precisely, as this order becomes increasingly definite, increasingly certain, increasingly extensive. But it is not clear that, to the exact extent that order does exist in the actions of the group, members' disputes are non-existent. Disputes mean, precisely to the extent that they occur, an absence of achieved order. Settlement of disputes in any fashion means re-establishment of the old order, or as the case may be, a new establishment of a somewhat different order in the group. An order is, to 95 or 99%, a question of the existence of ways or patterns of action among the members of the group, and of the organization of those ways into the interlocking complex sets of ways we know as institutions, ways common to all, and ways of some complementary to ways of others. And settlement of disputes is, too, a question primarily of ways. Ways called into play when the more normal ways of doing hit a snag. Now, between civilization and order, the main relations seem to be these. Order is a part of civilization, if only because civilization is a method of group life, and group life without order is inconceivable. Moreover, it seems to be fairly clear that what we call a high degree of civilization, a complex structure of cooperation, an effective way of coping with the environment, which gives some high assurance of survival to the group, is possible only on the basis of a very considerable degree of order. We could not run our present specialized economic life, relying on the West or the Argentine for meat, the East and South for coal, Brazil for coffee, and Detroit for automobiles, wondering whether we are troubled by grain sales from Russia, unless there existed as part of our civilization a fairly predictable set of ways that somewhat assured the specialized producer of a market, and assured the consumer that he can, without undue trouble, find someone to supply most of what he wants. And it would seem to be a fairly safe assumption that if any man with magnetism and skill enough to gather a gang of gunmen were wholly free to disregard our expectations, to take what he could seize, then savings, investments, and trade would undergo what we should think of as degeneration, and the resulting picture would increasingly approach the situation in such a country as Albania, where life is much simpler, wealth less, and a semi-feudal system of contending chiefs maintain what we think of as an irregular and half-war-like existence, so that it would appear some order, indeed a high degree of order, is a necessary basis for a complex civilization. A conclusion buttressed somewhat further by the fact that we know of no complex civilization which has arisen or survived without such order. The Italian cities at the time of the Condottieri and various phases of life in China are the extreme cases that I happen to know of. They suggest strongly, as I read the evidence, the limits of the growth available. Industrialism in any modern sense halts and staggers under the shock of upset traffic, of repeated forced loans and levies. Especially is sustained trade in low-priced commodities embarrassed. Commerce is possible, but the heavy commerce runs to the luxury field, to quick turnover rather than to long investments, except within the relatively smaller units where a single war chief monopolizes for a while the privilege of exactions. Who he is makes less difference than that he shall not be displaced too often. Art can flourish, indeed the war chief's spending may encourage it. The common man finds life a sorry business. Famine, given low transport facilities, is inevitable locally as crops fail from time to time. Consider how this holds for present China, even with the constant tapping of the reservoir of the better-ordered peoples. Written in 1930. On the other hand, too high a degree of order seems to paralyze change, to freeze a society into inability to cope with emergencies. This statement may of course be merely a repetition in one half of the sentence of what is already contained in the other. Too high a degree of order may mean nothing more than a situation in which change cannot be coped with. But I think there is more to the matter than that. I think that in a regime of almost total predictability, men are likely to lose the elasticity of mind which is necessary to work out new adjustments. Without the unexpected to deal with, it is not easy to keep fit to meet the unexpected. So that I take it we want order enough to get on with, but free play and unpredictability enough to keep at least some minds in the community elastic. To which I suspect that most modern men, and certainly I would add, free play enough too, to keep life interesting. It is the presence of this free play in society which makes one great need for law. For in the realm of free play disputes arise. Before I come to that phase of disputes, I wish to look at one other. There is one type of dispute which arises, not because the social scheme admits of free individual action, but because some individual or group refuses to abide by the social scheme where it does not admit free action. By and large, the basic order in our society, and for that matter in any society, is not produced by law, And one of the most misleading claims that has ever been put forward for law's contribution to civilization is the notion that it is law from which the basic order flows. The basic order grows, I repeat, not from law, but at least every generation from the process of education. With that process, law may have much to do, but the much is not too much. Official law may have its due part in the institution of public schools. The presence of policemen on the beat may have some part in keeping small boys from breaking windows and taking apples, in getting them into the habit of refraining from breaking and taking other things. Indeed, the activities of the police may have some important part in keeping bad examples from being constantly before the boy, in turning bad examples into horrible examples instead. But all that taken together amounts to very little. When compared with education as a whole, law plays mostly upon the fringes. But how big a part education plays in producing order in the group one can only realize, I think, by close observation of young children. Certainly the child is born into the world, a squalling wild man, a small bundle of barbarity. Outlandish, unformed, as is no barbarian our records give us knowledge of. But from the beginning that small bundle is put through a learning process which turns him out as early as the age of 5, a fairly civilized human being. And this, you will note, before the process of organized education has begun to take hold at all. The learning goes on partly by the child's observation and imitation of what goes on around him, partly by way of careful and patient urging learning to speak in the approved manner of his household, partly by an interminable series of checks, not always so patient on the child's experiments in action. His resourcefulness in finding things to do, or break, or upset, or to make noises with, is boundless, is inexhaustible. But over the years, his experiments along these lines result in a series of don'ts and slaps on the one hand, and a series of praises and pats on the other, bring him into holding himself back from conduct not approved, and let his energies loose along lines of conduct that find approval. And it is the group ways, the order of his group, which make for approval or for disapproval of his experiments in speaking or striking or manipulating. At the same time, he learns what he may expect and what is expected of him. In a word, he becomes an ordered part of the order of his group, an American, not a Frenchman, a city and not a country boy, equipped with subgroup in status. But we know that for one reason or another, this learning process is imperfect in some individuals. In some individuals, various native desires, whether or not stirred by particular chance contacts that we can trace, break through the accepted mold. While the child is in the home, this goes by the name of naughtiness. When he gets out of the home, it goes by the name of badness or queerness, and in due course delinquency or brilliance. When he becomes an adult, we call it criminality on the one hand and greatness on the other. And one thing to which I should like to recur is that much crime is one price we pay for greatness. For the same imperfections in our scheme of teaching, which keep the spirit of the great from being broken, are those which keep other lads of energy, resourcefulness, or peculiar self-will running counter to the law. We do not beat and starve and torture youth into perfect receptivity, as do the old men of so many simpler cultures. Our stamp upon youth is neither as firm nor as sharp as theirs. We do not shape youth wholly to our order. Youth can experiment, but no means has yet been devised for giving play to experiment, which does not result in trouble quite as well as in advance, in experiments that bother us quite as much as in those that we rejoice in. One type of trouble and dispute, then, with which law must deal, will be the experiment of the moron, the psychopath, or the pirate, in ways and places which the group as a whole wishes most distinctly let alone. To sum up what I have said thus far, I conceive civilization as based upon and containing a wide core of established order, which we are the less conscious of because we breathe it like the air, and a much smaller field of relatively free play. Here and there some man, for some reason, attempts to break through the established core of order. Moreover, within the field of free movement, interests of different individuals are in constant flux and clash. One man can run free in that field, but two men, each running free, may bump. In the field of free play disputes arise, Law did not create the order, but law attempts to guarantee its continuance. Law does not create the sphere of free movement, nor control very much of it. But the office of law is to make sure as far as may be that the clashes of interest within that sphere run off without disturbing the great core of order. And in cases where the ordinary processes of bargain competition, wearing down economic and social pressure, fail to produce a workable result or offer machinery to settle particular disputes and give us all a new foundation for getting on. Disputes between single individuals and between organized corporations, those business groups that are so tightly organized that we can treat them as units, law settles, chiefly through courts, when it is called upon. Disputes between wider, less organized groups or classes, such as the beet sugar growers and the consumers, between factory workmen at large and employers at large, between lumbermen and conservationists, law is more likely to settle by sweeping regulation through the legislature. Administrative officials, commissioners, mayors, police captains serve now in the one capacity, now in the other, today passing on an individual case, tomorrow laying down a regulation in advance as to the method of assessing property taxes, or the rates that shall be charged for telephone services, or whether the traffic lights are to be enforced against pedestrians. Seen thus, perhaps, law appears to be a tiny thing, an infinitesimal part of civilization. In a similar way, medicine may perhaps appear to be a tiny thing. Few of us are interested in the doctor while we are well, or until an epidemic threatens. But like medicine, law is needed desperately when it is needed at all. It operates upon the fringe. But that fringe is a fringe of high necessity. And also, as is the case with medicine, intelligent use of law is often capable of so arranging matters that this climax of need has no occasion to occur. Or, if I may have resort to another image, it is a safety valve, a minor and unimportant feature of an engine, most of the time. But how important this safety valve law is, one finds it difficult to realize until one sets himself to studying societies which are attempting to get on without it. I do not mean societies which had looked at the possibility of law and had deliberately rejected it. I know of no case in which that has occurred. I mean societies which had not yet invented the machinery with which we are so familiar, or to whom the inventions were novel playthings, toys as yet, of a few, and no integral part of the makeup of the whole civilization. In our culture and many others before law, we find the blood feud. A man's strength is in his kin, and for a man his kin must share responsibility. If A kills B, clan war ensues. B's kin are not particularly interested in killing A. Their honor will be satisfied in killing any of the A's, and in the process of satisfying it, they may kill several. But even if they kill himself, the A's will not regard that as closing the affair. Their honor was involved in protection of their kinsman, in his protection, even when he was wrong. His death, though in one sense an expiation, is in another a challenge to reprisals. In logic always, and in practice often, there is no end until one blood or the other is wiped out. Into such a situation law, in its crudest form, has cut along 3 lines. I will mention them all to show how various the approach may be, but even more to show through that variety how difficult the invention of a good system of non-violent adjustment is. One road is through regulation of the fighting. Before attack, it becomes accepted practice to serve notice that the war is on, with perhaps a period of waiting, and perhaps fixed times of truce. Or perhaps, as once in Iceland, it is a breach of fighting manners to surround and burn a house, instead of calling the inhabitants out into the open for the fight. Or perhaps, as in ancient Israel, note is taken of the fact that sometimes killings may be done in accident, and should then stand on a different footing from killings done intentionally. There the rule was that the killer might flee to a city of refuge. If the avenger of blood caught him on the way, a vengeance killing was in order. But if the killer reached the city, then he was to be brought back for trial before the congregation to see whether he had killed with intent. If he had, he was delivered over to the avenger of blood, but if not, he remained safe, but in exile, in the city of refuge. You will observe the great care taken to avoid provoking the avenger, by letting the killer of his kinsman stay within his sight. All this may seem to you exceedingly crude, but stop and consider how big the gap is between brute sudden attack and requiring a declaration of the feud. And again, how big the gap between merely requiring a declaration of war and inventing a city of refuge. A second angle of cutting into the same problem is to avoid continuance of the feud, the constant roll-up of killing following killing, by laying down a rule of like for like. An eye for an eye and a tooth for a tooth. Again, this may seem crude, but consider what a sacrifice of fighting propensities was required on the part of the avengers. What a sacrifice of pride on the part of the offender's kinsman. Still, a third line into the problem is found in the practice of composition, by buying off vengeance for a price, and on the other hand, of preventing war by insisting on acceptance of an offer of a price. This is a system out of which our own law grew. Its echoes still run through the civil suit for damages for injury to person or to property, or for breach of contract. A most modern innovation, not, I think, an echo, but a parallel development is found in the schedules of a workman's compensation act, in which the amount that an injured workman's employer must pay him is fixed according to whether he has lost a finger or a hand, the sight of one eye or of both. It will not do to think of the price list for injuries as the outworn crudity of barbarians when we find ourselves returning to something closely like it in one of the most modern of our laws. Modern and ancient, the problem is the same. Modern and ancient, each painful partial solution makes a little broader, a little more secure, the foundation on which all of civilization has to rest. Always the same problem: to find some means of adjusting disputes, some means of regulating the conflict of interests without disturbing other people, without endangering the peace of the non-disputants, without threatening the strength of the society or the solid core of order on which society must rest. For the fighting out of quarrels affects more than the participants. The commerce of the western cattle towns could gain no solid footing until the quarrels and feuds of rival cattlemen were kept from being fought out on the streets. When gang war gets too heavy today, we find either that shopkeepers shut up shop and move, or else that the military are called in for policing. Perhaps, however, I have stressed too much the criminal side of law, the adjustment of the graver breaches of the peace. The mind moves too readily to the criminal court as the type of all law. We must not let it rest there. The work of most lawyers, of most courts and most legislatures, and most of the ordinary individual's contacts with the law lie, as we have seen, in a wholly different field, not on the criminal, but on the civil side. In the adjustment of disputes and conflicts between individuals and groups which have no connection with the jails. Here, too, in the regulation of business, in the enforcement of contracts, in the division of property, law plays a vital part in stiffening the order of society. Peculiarly with property and contract, we find this stiffening. The taboo on touching others' goods breaks down in unfamiliar circumstances. The farmer's dogwood blossoms travel off in city cars. The lure of the rising market can become too great, and cashiers borrow from the till, and squatters squat. Tenants refuse to move or to pay rent. Mortgagors fail to pay and still hold their land. The gentleman still sporting at the Ritz ignores his tailor. There is no question of the stiffening. But in the civil field, the law does more. No longer is the question exclusively, this you must not do, and that you must. You must not kill, except in time of war. In time of war you must enlist to kill. Ordering and forbidding has been the burden of the criminal law. But in the civil law, the law of transactions, the law of business, there is another aspect. Law there picks up and shapes and hardens, or sometimes even creates out of itself, a host of devices for accomplishing one's purposes. If a man wishes to dispose of his goods and land after death, he can do it by a will. If a man wishes to invest some assets in an enterprise without endangering the balance of his fortune, he can do it by way of a corporation. If a man wishes to make a loan for 20 years, and be sure that in spite of death and change of management, he will retain a prospect of repayment, he can do it by means of mortgage. If he wishes to procure use of land for 5 years without taking all the permanent hazards of its change in value, he can do it by a lease. The civil law is full of these devices to make it easier for people to accomplish what they want in their relations with other people, to make it easier for people to deal at long range or over long time periods, and still have some moderate guarantee that the arrangements made will stand. Nowhere in the field of contract does the law make arrangements wholly certain or the guarantee of performance wholly solid. Law is no substitute for sense. Your bond may be a legal bond, but will be worthless if the corporation whose bond it is falls prey to footless management or is engaged in footless enterprise. Your mortgage on a boom plot may be good in law and yet a piece of paper. But if the thing goes well, then law assures you that no mere change of management, no loss of your trusted friend by death, no severance of social relations by an intervening quarrel will kill off your prospect of repayment. So that, through these devices to get men's purposes accomplished, law and legal rights serve the property system and the business structure of the community as a framework. Bones are not flesh. They are not blood. They are not, it may be, very much alive, but they serve to hold up and to limit what is both flesh and blood and very much alive. Thus far I have spoken chiefly of the law that is at any given time, taken in relation to the life of that time. I have referred to the fact that disputes arose out of the fact that someone man kicked over the traces. I might refer equally to those other disputes which arise because two parties disagree about the facts. Did you make the promise I claim you made, or did you not? Have you performed as you agreed? We are likely to differ on that. The bank has been robbed. Did John Smith do it? You and he will have different views on that. These are questions which must be settled. But they can be settled on the basis of the order of society as it is. It is important that they be settled right. But let me insist upon a thing too often overlooked. It is more important still that they be settled. Indeed, the settling of disputes of fact right, instead of merely settling them, is both a sign and a responsibility of the presence in society of enough surplus energy to spend some of it on more than the mere struggle for existence, like the radio, silk stockings, and the motor. It is a luxury which grows into a necessity, though fewer people are alive to its necessity. One other phase of this difficulty of social invention I must get before you. It is common to all legal institutions. It is common indeed to all social institutions, but it shows up with peculiar clarity in the machinery for settling disputes. One machine will be constantly put to and used for several purposes, but the needs of the various purposes are not the same, and to accomplish one is to defeat another. If I have a just claim against you, it needs collection. Speed is the need. If I have a dispute upon the facts with you, it needs a hearing. Settlement is needed, but fairness counts for more than speed. If fairness is to be judged by a standard from the community, and not by the special ritualists, a lay tribunal is called for. But if I have a dispute with you about the ritual, only a ritual expert can decide it, and it may call for an appeal to the most expert of them all. Now, all of these types of case tend constantly to be drawn into the same tribunal, and no man knows in advance which type of case is up. Then sham disputes about fact and sham disputes about ritual defeat speed in the just collection, and the lay tribunal handling the facts works at cross purposes with the official handling the rules, and the complex machinery makes possible the eternal dragging out of unjust claims. All of this, in the courts as in other social institutions, calls for conscious readjustment. To diagnose the various purposes a given piece of machinery serves, to refine and specialize the machinery to accomplish each of them, to devise a sieve to throw each type of problem to its proper specialized machine. This is one lesson of industrial technique, of factory management for law. Some of the lesson we have learned, as when we specialize our courts, set up commissions, even set a jury off to try the facts. Yet we are far from adequacy here. This is an instance where the planning aspect of the law has lagged behind the folkways of self-maintenance, of industry, of machine design. There are now other disputes which arise within the fringe of free movement, and which cannot be settled on the basis of society as it exists. Dairymen are threatened by the manufacture of a new filled cheese or milk in cans. It may be healthful. It is cheap. The filled cheese maker profits. The dairyman suffers, yet he claims that only he makes filled cheese possible, and he wants profits. Or the apple tree is killed by cedar rust. The only known protection is to cut down cedar trees. Apple growers want the cedar trees cut down. Those who have and love cedar trees do not. Someone is bound to suffer. Shall we do nothing and let the apple growers howl? Shall we cut down the cedar trees? Shall we have war? In the moving fringes of conflict of interest, have we no machinery for adjustment? Again, I wish to insist that the machinery we have, to wit, the legislature, and the use of that machinery for the purpose, is not a thing which can be taken for granted, is not a thing which every society has known. On the contrary, it has been by the slowest and most painful growth that we have moved an increasing body of disputes over into that field of orderly adjustment. I need only to remind you that in 15th century England, and in a Rome more highly civilized by far, they fought their elections out by arms. Within the memory of living man, the privilege of stuffing the ballot box in New York City was the prize of combat between gangs of thugs. Rhode Island, Texas, and Oklahoma have witnessed reminders of such practices within 5 years. And what of the revolutions in South America and Europe? Still, more often than not, a strike means violence on one side or the other or on both. This shifting of readjustments in the order of society to the sphere of order and of peace means a tremendous alteration in civilization. It means the growth as part of the great core of order in civilization, of machinery for working out the remodeling of the core itself. It represents the addition to the nervous system and the skeleton of the body politic, of the cortex of the brain. A machinery for taking in new conditions, and for finding new means of action, and of regulating action which will keep the whole from disintegration. Like the work of the cortex, the work of the legislature is partially stupid, partially disregardful of the facts, highly irrational too much of the time. Like the work of the cortex, however, the work of the legislature, with all its blundering, does manage to keep matters bearable. And if we can claim no more than that for our individual persons, it is not surprising that that should be the limit of the performance of all of us together. If we try now to put together all of this, what does it come to? Law in any form is an achievement of painful, slow invention, and probably, like most inventions, dependent in first instance upon accident. Its more developed forms are the product of whole series of inventions, yet lag far behind the technique of physical production. Law consumes energy in its creation, consumes energy in its operation. What does it offer in return? At first sight, nothing. Order exists without law. Order continues. Yet maintenance upkeep is also one problem of a plant, and law seems to be the maintenance department of this order, which is in turn a precondition to civilization itself. As to tools, law has borrowed copiously from the rest of culture. Language, logic, writing. And for the subject matter of its thinking it borrows the whole stock of practices, standards, ethics that make up the social, economic, and religious phases of society. What is dominant in society, then, is dominant in law. If oppression is the keynote of society, then so of law. But even as to the oppressor, law accomplishes something that other phases of order may not. Law makes order express. It thus sets limits, some limits, even on oppression. Stop and consider. It is no slight thing to be sure that the oppression you are open to extends only to the more established forms. And law has through the years gone far to guarantee you that. To guarantee you against the free play of ingenuity in your tyrant. Law, then, maintains the order as it is. Yet, as it is means with its play of change. And here we find law at work on change. It offers, in its machinery for dispute adjustment courts, legislatures, and administrators simultaneously a machinery for authoritative choice among experiments. Thus limiting experiment, but concentrating it within the fields thus limited. Thus, too, guaranteeing the continuance of such experiments as it accepts. Here then is a positive contribution to our civilization. One other possible contribution of law to civilization I should like to mention, although as to it I must speak with great hesitancy, and with the feeling that I am guessing rather than talking of what we have some reasonable assurance of. I refer to law's part in the intellectual developments of our society. I strongly suspect that the conception of order in the universe to which we still refer as law of nature is derived in great part from the conception of law as the fundamental order of society. That old grandfather law, who survives today as perhaps the least scientific of important disciplines, is yet to be credited with having had an important part in his youth in bringing the natural sciences into the world. More, disputes arise when differences are perceived. And when disputes arise, differences are perceived. And the urge to deal with like things alike, which pervades law from the earliest times, forces men to generalizing about likenesses and differences. And while I am here on the most uncertain of ground, I am also strongly inclined to believe that one of the earliest and most persistent stimuli to the growth of generalization and classification, and so of rational thought, especially that branch of rational thought which we call formal logic, is attributable more to law than to any other phase of civilization, except perhaps language. I should argue that later students of logic and language might do well to make contact again with such a wellspring. Finally, I think it is to law that we owe the conception of justice. I am not wholly sure of this. There is a very remote chance that the matter runs the other way, that we owe law to the concept of justice. There is a greater chance that both are shoots of the same root. Still, I think law as a discipline may claim the concept. It should, if it can, for the concept marks a noble achievement. As legislation offers the wherewithal for readjusting that same order which brought forth the device of legislation, so justice and the law. Recall what I have said before of social justice, and of the confusion of social injustice with the workings of the law. Here law, at the point of pressure, by its own weight calls its own concept to its own perfection. There are few social institutions that can boast of self-sanation. Indeed, this idea of self-sanation, the proof of its possibility, the provision and testing of machinery for its accomplishment, these may be not the least of law's contributions.